All right. This court is now in session. Please be seated.
Good morning. This is the second case on our docket for the first day of the July 2020 session of the Court of Criminal Appeals in Nashville. Thank you for cooperating and being here under these unique circumstances that we have in the world today. We're just glad that we're able to have oral arguments in court and not just on Skype or Zoom or whatever. Of course, we're required to wear a mask under the most recent Supreme Court order. We have, the court will, members of the court will probably leave their mask on during the proceeding, but if the lawyers choose to, number one, argue from the table, we did that in June and it worked out fine. We ask that you sit down to argue if you choose to argue from the table, so the microphone can pick it up. You'll probably be a little more comfortable. But if you need to remove your mask while you're addressing the court, that's okay. One reason that I think we can do that is that we're obviously well social distanced. There's nobody within 20 feet of you and probably nobody within 15 feet of you. So if you need to remove your mask during your argument part, and when you're not addressing the court, we'd ask you to put your mask back on. To my left is Judge Tim Easter of Franklin. To my right is Judge Bobby Holloway from Columbia, and I'm Tommy Woodall from Dixon, Tennessee. Each side has 20 minutes. If you represent the appellant, you can reserve, let me know, and you can reserve some of your 20 minutes for rebuttal. Is there anything else that needs to be addressed? Okay. We had this come up in the last case. Judge Holloway was asking a question. The appellant's lawyer was looking directly at Judge Easter, which is understandable. You can't see whose lips are moving. So if you see one of us going like this or like this, that's who's addressing you. So you may want to turn your head, but the appellant's lawyer was intently looking at Judge Easter while Judge Holloway was asking him a question.
And it was a horrible question. I did not want to.
So if you have difficulty hearing us answer, please let us know. And so with that, it's 10:49. So we'll start at that point, and the appellant can go first now.
May it please the court, do you have a preference on whether I sit down or stand up, or does it make any difference one way or the other?
It doesn't make any difference, whichever. If you're going to stay at your table, you're welcome to sit down. I think we'll hear you better with the microphone being closer to you.
Okay, well, if you cannot hear me, then just please let me know.
Oh, we will. We will.
Okay. Well, may it please the court, I am Mark Scruggs of the Nashville Bar, and I represent the defendant appellant in this case, Tommy Charles Simpson. I would like to reserve 3 minutes for a possible rebuttal.
All right.
May it please the court, this is a case that is up here on a certified question, which contrary to the state's assertion, I believe is clearly articulated within the brief. And that is simply that whether or not Vladi Gajovic, who was a security guard for the Bikini Beach Bar at the time my client's phone was seized and searched by him, was a state actor acting for the police department or for the state in searching my client's phone. It is our position that he was, and that is a clear violation of Raleigh versus California. And the trial judge recognized that. The assistant district attorney recognized that. And I don't know how we could articulate it any more clear in the record before this court. I would submit to the court that this is an important case to the extent that the limits or the scope, I guess, of the Fourth Amendment and how it applies to persons who are not directly employed by the police department. That's the issue here. And this is unique in the sense that the regulatory structure of the metropolitan government of Nashville-Davidson County through its police department has established that security guards, licensed security guards, are the first line of defense in bars, places that serve alcohol, since they do not allow their officers to serve as security guards in these settings. That's what makes this especially unique. Even though the state attorney general opinions and the state statutes that regulate security guards seem to give them the authority to act as police officers, they come back and say they're not police officers. So it's sort of like they want to have their cake and eat it too. But if you look at that in combination with the regulatory structure of Davidson County, where police officers are not allowed to be security guards in bars or places that serve alcohol, then that's the straw or the weight that tips this over in favor of the fact that Mr. Vladi was acting as a state actor in this particular setting. What happened is that Mr. Simpson was a customer of this bar, the Bikini Beach Bar. It's out on Antioch Pike and Harding Place. I'm sure y'all been there before, but and they do have some very interesting decor, to say the least. But nevertheless, he was there and he left his phone on the counter, and apparently it was seized by Mr. Vladi and searched by him, and who then called the police, and the police later got a search warrant for that. But Mr. Vladi is the person who actually searched the phone and found the objectionable pictures on that. And that's what led to the probable cause for the officers to obtain the search warrant. So basically, Vladi was acting as a police officer in that situation. And the record that you have before this court supports all that. The state did not call Mr. Vladi. We could not find Mr. Vladi. So it's basically uncontested what he did. And it's uncontested what the regulatory structure is. So the court, the trial judge, applied the test that was in effect at that time, and that is still in effect. It's called the independent motivation test that you find in the Burroughs case, and said that she could not find that he had any independent motivation to assist the police. We would respectfully submit that the record does not support that he acted solely as a police officer in searching the phone and sending it to the police. That's exactly what he was doing. And there's really no evidence in the record before this court that suggests otherwise. Now, we also cited two other tests, which I think should be considered by the court as well. The public function test that comes from a case out of Michigan in the Sixth Circuit, where security guards were allowed there in Michigan to basically be in charge of police functions in casinos. And that's pretty much the same thing you have here. That, again, it's unique to Davidson County. And in that particular case, the court held that that was a state actor, that the security guard was a state actor, and that was for purposes of a civil rights claim or excessive force civil rights claim. The other test that we cited.
Is that any different from a Fourth Amendment claim, and that the case, the casino case was a civil action, a civil lawsuit, wasn't it?
Right, but it's based upon violation of constitutional rights. And those constitutional rights revolve around the Fourth and 14th Amendments to the United States Constitution. And the concept of state actor, we would submit, is the same concept you have within the Fourth Amendment. It doesn't make much sense to me to have a different definition for state actor in different scenarios. A state actor is a state actor. But we would submit in this particular case that he satisfies the public function test, given the unique nature of the regulatory system in Davidson County.
Well, Davidson County does not require a bar to have a security guard that's licensed, do they?
It does not. It does not. But in this particular case, he was the only licensed security guard who was there. But it does not allow their own police officers to work there.
And that is from probably, if I understood something in the brief, it sounded like they prohibit that so it doesn't have a conflict of interest where a police officer is moonlighting in a bar that, and getting paid in a bar that he or she may have to make a decision against if there's something unlawful going on.
That could be one of the reasons. I think the other reason is that the metropolitan government is so concerned about liability that they're simply not going to allow their officers to be exposed to potential liability in that particular setting, which of course that could come back to haunt the Metropolitan Police Department as well. So for whatever those reasons are, it is what it is. And again, I want to emphasize the unique regulatory nature that we have here. And that allows me to sort of segue myself into the Brentwood Academy versus TSSAA case in terms of what constitutes a state actor. And again, that's for, I believe, 14th Amendment purposes as well. But here you have an excessive entanglement to the extent that you have private security guards who are heavily regulated by the state. And in turn, you have this symbiosis of security guards in Davidson County who are the first line of defense for establishments that serve alcohol. So I hate to sound like a broken record, but based upon the record before this court, Vladdy didn't testify. We presented witnesses who talked about the policy. We introduced the policy of the metropolitan government. Therefore, we would submit that the trial judge erred in not finding that Mr. Vladdy was a state actor. If he's a state actor, basically he's a cop. He searches the phone, he finds the evidence. Then, of course, they use that to go get a search warrant. The subsequent search warrant cannot cure his illegal search of that phone. And as I said before, the trial judge recognized what the issue was. The assistant district attorney recognized what the issue was. We all agreed that if this court finds that Mr. Vladdy was a state actor and therefore he illegally searched that phone, then all the evidence obtained from the phone, as well as evidence subsequently found in his house from another search warrant based upon the previous facts, should all be suppressed and that the charges should be dismissed.
Let me ask you, Mr. Scruggs, you said the private security guard, you could not find him, so he did not appear at the motion to suppress or at the plea.
That is correct.
And I was thinking the trial court made a finding that he wasn't searching the phone. He was looking at the phone to try to determine who the owner was and saw these photographs.
I don't believe there's any evidence in the record to support that. I mean, she can't read the man's mind. Nobody could read his mind to find out what he was doing specifically and why he was doing it. But we do know that he did search that phone and he did hold on to it and then reported all this to the police. Even after Mr. Simpson came back looking for it. It was hidden from him when he came back to the bar later that evening and was told the phone could not be found. Mr. Vladdy had it and was giving it to the police at that time. That's basically my argument. If the court has any questions, I'll turn it over to the other side.
Who testified from the bar about his
Ms.
respons-
Slate, the bar owner, she testified regarding what Mr. Vladdy's duties were. He basically was their only licensed security guard, and he was responsible for keeping order. That was his job. I mean, what's interesting about it is, again, like I said, this is a biker bar, folks. Okay, so this is potentially a rough kind of bar, but it's within about, if you know where it is, it's within about, I'd say maybe a quarter of a mile or half a mile of the precinct down there. It's next there behind Sam's. And they had a panic button as well. So if something happened, they could press that button and it went straight to the police department as well. So, but Vladdy was the first line of defense for the police there.
But he was not armed
No, he was not armed.
and not wearing any kind of badge. I think he
He
had a
the
T-shirt
He had the shirt on, yeah,
and no uniform other than the shirt.
correct.
Did I see something in the brief about whether or not he had the authority to arrest
That-
a customer?
That is confusing, okay? That's very confusing. I believe if you look at the Attorney General opinions, is that a private security guard has the same authority to arrest someone as a private citizen. He could make a citizen's arrest, all right? And I mean, I guess I just don't know what the significance of that is one way or the other, because he could make an arrest. It would be a citizen's arrest, and the Attorney General opinion says, well, you do that at your own peril, you know? So
Well, if he doesn't, how can he be a state actor if he, as a police officer, if he has no more power to make an arrest or a seizure than any other citizen in that bar at the time?
well, making an arrest is seizing someone, whether it's done by a citizen or a police officer. Just because a police officer makes the arrest doesn't insulate him from potential liability for the manner of the arrest or anything like that. I think what it comes down to is his duty to enforce the law while he's in there, and he's the only one. So let's just say he sees a fight or something like that. He can hold those people. Security guards do this all the time. They hold people. I've had numerous cases where that happens. They hold people until the police come down to make a quote formal arrest and booking and everything else. So it's a seizure is what it is.
But he didn't hold your client, did he, when he came back?
My client was gone. My client was gone.
No, when he came back asking about his phone, nobody made
think-
him stay at the
think at
bar,
that-
did they?
I think at that time, Vladdy was gone. He was already on his way to see the police. He was not there in the building when he came back. It was another bartender or something like that he talked to. You see, what had happened is that my client, I think, pinged his phone from his computer or something like that, and realized it was still in that location. So he came back to look for it. But when he came back, I believe Vladdy was gone. It wasn't a matter that he could go and confront the man one way or the other.
Do you have anything else to address about the state saying the certified question was not proper?
Judge, I would simply say that I don't know how clear we could make it. We articulated the issue as whether or not Mr. Vladdy, the security guard, was a state actor. And if he was a state actor, then he violated the Fourth Amendment, Raleigh versus California, by searching the phone without a warrant. So again, the trial judge agreed that that was dispositive. The assistant district attorney agreed that that was dispositive. So I don't know where the confusion is with regard to the issue that's been articulated before this court.
Well, you argued that it would affect, that if he was a state actor, that would affect under fruit of the poisonous tree, all the other evidence they got, but that's not included in your certified question.
Well, that's what we
And let
agree.
me say that it's been a while since I have seen a brief on a certified question where the state hasn't raised the issue of waiver or improper certified question, and it's not an easy rule to follow, it seems like.
Well, I've lost cases. I mean, 20 years ago, I learned it the hard way, that I didn't articulate it clearly enough. And when we do this down in the trial level, we try to be as clear as we can be, because we know this is coming up here. So I guess I just don't know what else. I mean, by dispositive, that means that the fruit of the poisonous tree applies.
Well,
That's
not necessarily, because and I'm not saying it's fair, and I'm not saying it's the best way to do it, but I have to follow what the Supreme Court has laid out. And it seems to me that everything has to be in that certified question. And I remember 20 years ago, there was a lawyer that tried a DUI case and had one search issue, and that was all argued. And I think the record showed it took about 2 hours to try the case. And Judge Smith, who was formerly on this court, asked the lawyer, said, "Why didn't you do a certified question?" He said, "Your Honor, it's easier just to try the case in front of the judge and bring it up on direct appeal, and then have to worry about things being waived." And, that's not necessarily, what the situation you have, I guess, but, if it just said constitutes state action, if we find, based on just what you put in your certified question, which that's all we can look at. We can't go in the record and look at fruit of the poisonous tree. It doesn't say anything about that. And if we say, yes, he was a state actor, but was that evidence that would have been found anyway? Was that the situation where it was attenuated? I'm not going to talking about what the answer to that question is, but for us to be able, we're restricted. All we can do is affirm or reverse and dismiss the charges. That's all we can do. We can't send something back for further hearings. And like I say, I don't necessarily agree with all the hurdles that have to be jumped on this, but it is what it is.
Judge, if I may, in the record, the judge entered an order. Now, the certified question that I have set out on page 6 of my brief is only part of that order. And that order goes on to say that this is dispositive of the case. So I don't have that order in front of me, but if the court would look at the actual order that was entered at the time of the plea, it has all of that language in there. And that order was entered simultaneously with the judgment. So I've got here, I think it was on the record pages 340 and 350. So if you go back and look at that order, I think you'll see it has all the language in there regarding if this court finds that he was a state actor, then all the other evidence would be inadmissible.
Okay. You have, I've kept you tied up and used up your rebuttal minutes, but I'll give you 2 more if you're wrapped up. You need 2 more minutes.
Thank you.
Okay. You ready for the state?
Good morning, Your Honors. May it please the court. Sophia Lee on behalf of the state. Your Honors, regarding the certified question, the state's first issue, I can understand there might be some confusion regarding the procedure here, because typically you have to have the agreement among 3 parties at the trial court, and it does involve the agreement among the trial court, the state, and the defendant. Obviously, our office is not involved in that discussion when it occurs at the trial court level. With all due respect to our sibling prosecutors, we're not actually bound by that decision, just like this court is not bound by the decision of the trial court in agreeing and finding that an issue is dispositive. Now, in terms of the actual issue, as Your Honor pointed out, I actually thought he was just talking about the images that were found in the cell phone. Now, I know that they did execute a search warrant of his home, but I thought it was limited to what was found on his cell phone, just based on the issue that was presented. Another problem with the certified question is Riley v. California. Now that case did involve a search of a cell phone, but it was conducted by a police officer. That is not the issue here. And so the authority that he relies on, that he incorporates in his certified question, isn't even relevant to his issue. And that's one of the problems in this particular case. Now, this is an interesting question. He raises like 3 tests: the legitimate independent motivation test, the public function test, and the excessive employment test. None of those tests are mentioned in the certified question as a basis for finding the bouncer as a private actor. And so those are some of the reasons why we think that in this particular case, the issue is not clearly defined and it's overbroad. In terms of the merits of the issue, the state understands that this court can reject the state's argument that it is dispositive. Now, should the court decide to do that and address it on the merits, our position is that the defendant still cannot prevail. Number one, in terms of the legitimate independent motivation test, the bouncer did not testify. We had 2 hearings. The defendant testified at the first hearing, and the owner and Mr. Shagag and Mr. Mason, the 2 experts, testified at the second hearing. The trial court, based on the detective who actually talked to the bouncer and then obtained a search warrant, he also testified. And so based on the conversation that he had with the bouncer, he went ahead and obtained a search warrant. He found that there was probable cause that there might be images of child pornography. When you look at the independent motivation test, you have to look at the motivation of the bouncer. From the evidence, the bouncer, when he found that there was a phone, someone had left it behind, his intent was to locate its owner. There was
Where does that proof come from?
Your Honor, that was from Detective Kerrigan's testimony when he said that he interviewed the bouncer to get a better understanding of what the bouncer saw on the phone.
And there was no objection as to that being hearsay?
No, Your Honor,
Okay.
that's not reflected in the record. So yes, it's unfortunate that he could not be located. So the trial court's findings would be based on Detective Kerrigan's testimony. And in terms of, and there was no indication that he did it for any other purpose other than to locate its owner. Now, when he did scroll through the phone and found the images, he then contacted an officer. There was a first officer who actually met him at a Waffle House. He then turned over that phone, but then when Detective Kerrigan was assigned to the case, he then met with the bouncer and conducted an interview. And that was the basis of Detective Kerrigan's testimony. Now, under the Supreme Court's decision in State v. Burroughs, you not only have to look at the private actor's motivation, but you also have to look at whether or not the police knew about it or acquiesced. And there's no indication in this case that that's what happened in terms of that he took it upon himself to look for suspicious activity by looking at the defendant's phone. And in terms of the 20% rule, my understanding is that it's a policy. I don't know if it's necessarily statute, but there's no, in terms of how it would apply and how it would somehow usurp the police power. My understanding is that if there is an establishment where more than 20% of the profits are generated by the sale of alcohol, then officers from the Metro Nashville Police Department are prohibited from seeking secondary employment. There's nothing in the proof to indicate that somehow that was in any way that kept the police from doing its particular job. Now, if you look at the facts of the case, the bouncer still contacted the police. The police were still involved. If you look at I'll move on to the public function test. In the public function test, which would be the Sixth Circuit case regarding the Michigan casino case, they actually had a statute in Michigan where the casino security guards were endowed with plenary police power. That's an important distinction. And number two, the police weren't in any way involved in that particular case. As you may recall, the plaintiff, because it was a 1983 action, The plaintiff was detained. I think she took a token that was in violation of the casino rules. She was detained for some time. They took her photograph, her driver's license and social security number. They basically kicked her out of the casino. There was some indication that the police were contacted, but they had no involvement whatsoever in the detention of the plaintiff in that case. And so because the casino guards stood in place of the police in terms of casino business, the Sixth Circuit said, under the public function test, you are a state actor and you can be sued as a state actor for purposes of a 1983 action. I mean, there's no indication that the 20% rule prohibited or actually put the bouncer in place of the police. And if you look at the statute that defines private security guards, whether they are armed or unarmed, there is a separate definition for sworn peace officers. Now, I believe that's section 6234-102, and they make a distinction between private armed security guards, private unarmed security guards, and sworn peace officers. And it's only a sworn peace officer who is imbued with plenary police power. And so that would be the main distinction between this case and Tennessee law and Michigan law regarding the public function test. Of course, lastly, I just want to hit upon the excessive employment test. That was also a 1983 action. And of course, the United States Supreme Court held in that particular case that the TSSAA was a state actor, because you've got the State Board of Education that supervises this private organization. So you've got involvement from the state from the top down. Majority of the members of this association, 84%, were composed of public schools. The bulk of their financial support came from public schools. And then apparently the members of this particular organization could participate in the state retirement fund. So based on all those factors, the United States Supreme Court said, this is excessive entwinement. It's unmistakable, it's excessive, and that's why they can be sued as a state actor for a 1983 action. Of course, the Fourth Amendment wasn't implicated, so it's kind of a bulky test to apply in this particular case. But the takeaway from that case is that there's got to be some kind of benefit. And the only benefit that can be found in this particular case was that somehow a bouncer like Mr. Vladimir Gochevic in this case didn't have to compete with police officers in the Metro Nashville Police Department. I mean, that's a very remote benefit, but that's not the kind of benefit that the United States Supreme Court had in mind in order to find excessive entwinement. And so for those reasons, we submit that the bouncer in this case was not a state actor under any of the three tests. And should this court decide not to dismiss the appeal, we ask that you affirm the judgment denying the motion to suppress.
Ms. Lee, I wanted to ask you a question if I could, please.
Yes, Your Honor.
This gets back to the first issue that the state raises, that the certified question the defendant sought to preserve is overly broad, non-specific. In that statement in your brief, are you referring to, as the certified question is phrased in the appellant's brief, or are you specifically talking about the order that the trial judge signed?
Your Honor, the order, which would be consistent with the issue that's set forth in the defendant's brief.
Well, I'm looking at the order in the record, and it's a two-page order.
Mm-hmm.
I didn't see all of that language. Maybe I overlooked it in Mr. Scruggs' brief, but I didn't see that. Is very specific, it seems to me, signed by the trial judge, signed by the assistant DA, and signed by two defense counsel. And your position is that order is overly broad and not specific enough.
Well, not specific would be our position. I mean,
I just want to make sure that I'm on the same page with what you're saying, because I'm looking at the order, and it's page 355 of the record, and it goes on for, well, a page and a half. But in any event, that's the order you're talking about.
I did not recall the order being quite that lengthy. Obviously, we have to start with the order as a basis for anytime we come across a certified question.
Mhm.
And of course, my recollection could be a little, may not be the best, but
Well,
I mean,
it looks like the order, when you read it, it really gets down to one or perhaps two paragraphs that sets out the certified question.
And Your Honor, if this court were to reject the state's argument that it's not overbroad, that it is specific, we certainly understand, and certainly that court, the court is certainly, has done that and can do that and probably will do that in this case. If the court addresses the certified question on the merits, if you try to apply the facts to all the three of the tests, we submit that he's not entitled to relief, and the trial court made the correct decision, notwithstanding the state's first issue regarding the certified question. If there are no further questions.
Very briefly, I'll leave you with two cliches. Number one is that the state is trying to have its cake and eat it too. In other words, they've endowed Mr. Vladdy with police powers, even though they say they're not doing that. That's basically what he is when it comes to the barroom setting. And number two is that if it looks like a duck and walks like a duck, it probably is a duck. And based upon the record that's before you, Mr. Vladdy looks like a police officer, he walks like a police officer, and he acts like a police officer. And that's where the state action comes into play. I would simply ask this court, which I know you will, you're going to take a very close look at all this and making your decision, but it just seems like the past 3 or 4 times I've been up here, it's been on Fourth Amendment cases and it's been on phones. And haven't had much luck with that, to be honest with you. But and each case stands on its own, of course. But I'm sure this court will take the Fourth Amendment as seriously as any court in this country. And I hope that in this particular case, I believe that the record will show that the state should not have its cake and eat it too.
Is the key point for your saying that he was a state actor, the fact that he was a licensed security guard?
Not only that, I think the key point that makes this different than everything else is the relationship the authority had through the metropolitan government's regulatory authority combined with the state. That's what makes this so unique. Since he was, in essence, the first line of defense for any type of illegal activity.
Did the metropolitan government do anything directly to name him a security guard, or are you just saying that they prohibit one of their police officers from working part-time in a bar?
That was the effect, yes, sir. They did not actually do a decree or anything like that or pass an ordinance, but the effect of their action made them the first line of defense. And by doing that, they can't have their cake and eat it too. They can't just say, okay, you're going to be our policeman in this establishment, but you don't have to obey the Constitution.
Okay. I'm having a hard time tying that in. Their prohibition from of allowing a police officer to work part-time in a bar somehow says your security guard will substitute for the police.
I'm not, Judge, I'm not sure if it's in the record. I think that I asked questions. If I didn't, then don't even consider this. But there was a big controversy. Police want the work. They wanted to work at these places, and establishments would rather have police officers because they have the uniform and the gun and everything else. And that was a very controversial policy. It cost officers a lot of money. So I believe what the metropolitan government did with their regulatory scheme, in effect, they created private security guards as the police officers for these establishments, the first line of defense. So I hope that makes sense.
Anything further?
Well, is there any authority where the metropolitan government created these private security guards? Or are you just saying that just something that developed as a result of prohibiting the police to go to these bars?
That's something that developed, and it is contained in the testimony of Mr. Shegog, as well as, more importantly, the retired police officer, Tim Mason, who testified regarding the policy as well. And the policy was introduced as an exhibit. I mean, it was the effect of the policy. Did they intend to do it that way? No, but that's the way they, with the environment they created when they said this, that you can't hire police officers anymore in these establishments.
What, if he was not a security guard licensed by the state, would you still be saying he was a state actor?
I think the argument would not be near as strong.
Okay. Anything else? Okay, thank you for participating and for your cooperation in the rules and all that we've set up for hearings at this time. And I believe we come back at 1:30. Okay, thank you. Thank you again.